evening, everyone. Thanks for the third instalment in a series of 3 financial remedies webinars hosted by 42 Bedford Row. Tonight, myself and my colleague, Katherine are going to talk to you about pets following relationship breakdown or divorce. So to set the scene of tonight's webinar, the animal charity Blue Cross has carried out some really interesting research about what happens to pets post-separation. So their research shows that 4 pets are taken in by Blue Cross every week following relationship breakdowns. Dogs and cats are the most fought over pets, perhaps not surprisingly, followed by horses, rabbits, and guinea pigs. When Brits split, it's usually the wife or girlfriend who keeps a pet, around 56%, whereas just under a third of men retain full ownership at around 29%. And for those who couldn't decide who should keep the pet, 15% decided to give them to a family friend, 12% to family members, and 6% to pet charities such as Blue Cross. So what I think this research shows is that who gets to keep the family pet is clearly a highly emotionally charged issue. And interestingly, it seems that more women than men retain the family pet. But I think it's clear that pets in divorce is very much a hot topic for family lawyers and particularly financial remedies practitioners. So that's very much going to be the focus of our webinar tonight. So I'm now going to hand over to my colleague Katherine, who's going to speak about the approach to pets in divorce in this jurisdiction.
Thank you, Charmaine. So the starting point is that English law still treats animals as chattels. So it's right that the Animal Welfare Act 2006 now does recognise the sentience of animals by creating offences of harming protected animals in specified ways and failing to ensure that their needs are met to an appropriate standard. However, outside of the Animal Welfare Act and from a civil law and family law perspective, despite being sentient beings, animals continue to be treated as chattels. And as I've put on the slide there, no different in principle to a car or a painting. Before coming on to the court's powers to readjust property ownership in financial remedy proceedings on divorce, which will be the focus of this webinar, it's worth addressing briefly how the courts identify where legal ownership of a pet lies in the first place. And that could be relevant in disputes between non-married couples who separate, or even more broadly, between a neighbour who takes possession of a pet that doesn't belong to them, for instance, by starting to feed a cat and then essentially adopting that cat. And even within financial remedies applications, a judge might be minded to try and identify where legal ownership lies before deciding how to redistribute the property rights. And given there is no legal register of pet ownership, unlike with land, for instance, a judge would determine where legal title lies, taking multiple factors into account, including, and I've listed them there, but things like who bought the pet, was the pet bought during the relationship, were the parties cohabiting at the time of purchase, who's registered on the microchip database, whose name is recorded at the vet's practice, who's registered on the insurance certificate, who usually takes care of the pet, who pays for the day-to-day expenses of the pet, who feeds it, etc., and was the pet bought as a gift. So it's clear there's no one determinative factor, but the court will use a range of indicators to establish the true ownership, legal ownership of a pet. Moving on from property ownership to looking at what powers the court has in financial remedy proceedings. We of course have section 24 of the Matrimonial Causes Act 1973, which gives the court power to make property adjustment orders, and then section 24A, which gives the court jurisdiction to make orders for the sale of property. And clearly chattels, including pets, are subject to those powers. And in determining how those powers will be exercised, the court will have regard to all the circumstances of the case, with first consideration being given to any child of the family while under 18, and the court will then have particular regard to the well-known section 25 factors, including the financial resources of the parties, their needs, and the standard of living they enjoy during the marriage. But specifically, there's no mention of animal welfare being a factor that the courts have to take into account when determining where a pet will end up. And that makes sense, given pets are treated as chattels, again, no differently in principle to any other chattel. There's also no provision within the Matrimonial Causes Act for a court to order that one party spends time with a pet retained by the other party in accordance with what might be in that pet's best interests. So in considering what that could look like, an analogy could be drawn with Section 8 orders under the Children Act for lives with and spend time with orders. But again, that would be at odds with the treatment of pets as chattels, rather than as sentient beings whose welfare is a relevant factor for the courts. So just looking first at the court's approach to chattels generally, not just pets, there's definitely a clear steer from the courts encouraging parties to sort these out themselves outside of court. And that's for obvious reasons connected to proportionality and the limited availability of court time. In K&K, the parties had amassed antiques worth around £330,000, but no steps had been taken prior to trial, prior to the final hearing, to try and resolve the division of those chattels. And the High Court was critical of that and noted that divisions of chattel can often be problematic, particularly where items of sentimental value are concerned. And I'd suggest that perhaps the most sentimental of all chattels would have to be the pet, given they're actually sentient beings that many people form strong emotional connections to. The judge gave in K&K a clear reminder that chattels should not be forgotten, and the division must be accomplished prior to trial. And if there isn't an agreement, a Scott schedule should be drawn up, and in that case, the parties then agreed they'd resolve the issue by each drawing up a list of their favourite items in descending order and make alternate choices until their respective lists were exhausted. And that's a fairly common mechanism which is adopted in the division of chattels where that isn't agreed between the parties. However, it's hard to see how a similar approach could be adopted to or applied to animals, unless there were multiple pets, but even in that case, the approach does seem somewhat insensitive. So if we move on to look at examples where the chattel in question is a pet, there isn't a great deal of case law, no doubt due to the fact that judges really do encourage parties to settle these matters outside of court. But one example is RK and RK from 2011, which was heard by Mr. Justice Moylan, as he then was. And that case principally centred on the extent to which resources held within a discretionary trust were a party's resources. But the wife also made a claim to one of the family dogs, which it seems had been retained by the husband after separation. And the judge there determined that he would make no order in respect of the claim by the wife, in respect of the dog. And the reason he gave was that the dog was seen to have been looked after principally by the husband. And it's not clear there from that short extract from the judgment, it's not clear if that reasoning was based on a conclusion that as a result of the husband being the dog's primary carer, he was therefore considered to be the true owner, the legal owner of the dog, or if it was instead as a result of some implicit consideration of the dog's welfare that should be considered, so it should stay with whoever's been looking after it. I would suggest most likely it's simply as a result of the very elastic concept of fairness that's applied in these sorts of cases on a very case-by-case basis. Another example of a judge declining to make any order on the issue of pets is the 2018 case of IX and IY, which dealt mainly with the issue of the issues of non-marital assets and unmatched contributions. The parties also, though, had two dogs, and when Mr. Justice Williams came on to the appropriate division of chattels, including those dogs, he said, "I believe that one dog is currently in France and one dog is in England. That seems to me to be fair. If the parties wish to argue over their access to the other dog, I would suggest they place the dispute before a mediator or arbitrator, perhaps one with experience of dogs." So again, he made no order on the pet issue, apparently on the basis that each party could retain the dog they currently had, and any other issues, he said, should be dealt with outside of court. A slightly different approach is the case of S and S. And in that case, one of the issues was whether the trial judge had erred in assessing the wife's housing needs and periodical payment needs to include enough to house and maintain her 3 horses. And having regard to the standard of living during the marriage and noting the wife's devotion and the time she had dedicated to these horses and the emotion she had towards these horses, the trial judge concluded, and it was upheld on appeal, that fairness dictated an award which gave the wife the means to retain her horses, to maintain them and enjoy them. So although that doesn't directly deal with the issue of who keeps a pet or animal on divorce, it does show that in certain circumstances, animals can have an impact on financial awards, which does seem to go beyond what would be expected of a mere chattel. It would be interesting to know if a similar approach would have been taken if, for example, the wife's hobby outside of work was, rather than horse riding and horse maintenance, whether if it was antiques collection. So, for example, if she needed a greater housing fund to store and maintain her antiques, whether that would have been approached by the judge in the same way, or whether it was the wife's evidence that she gave at trial that horses are her family, and that she has a real emotional connection to the horses, and whether it was that swung it for the judge. Given each case is highly fact specific, it's hard to say for sure. I'm now going to hand back over to Charmaine to look at what can be done outside of court to try and resolve these disputes.
Thank you, Katherine. So for those who don't want to rely on the court process, there are a number of mechanisms of alternative dispute resolution. So for instance, mediation and arbitration, as well as preemptive measures, colloquially called PETNUPs. In other words, pre or post-nuptial agreements that set out care and contact arrangements for the pets and so on. And given the steer given by the judge in IX and IY, it seems that mediation and arbitration are very useful forums to make decisions on things like who gets to spend time with the family pet and when. And certainly, as Katherine has already mentioned, the court doesn't have any powers to make orders about that. So it may be that out of court fora are most appropriate for things like contact. So I'm sure all of you already know what mediation and arbitration are, but I've just sort of set out very briefly on the slides what both of those mechanisms offer. And certainly it would be advisable, in my view, for a party to approach a professional mediator with particular expertise in disputes involving pets, or alternatively to go to arbitration. And the benefit of that is it will produce a binding outcome, but the process will be quicker and more streamlined than the court process. It might also be prudent to include a term in a pet nup, which I will turn to in a moment, that the parties will have recourse to ADR if the terms of the pet nup are reneged, or alternatively if the parties can't agree a specific issue. So for instance, what happens to the family dog when one of the former partners goes on holiday? Does it go into a kennel? Is it looked after by a neighbour? That sort of thing. So delving into pet nups a bit more, as I say, this is an agreement between the parties setting out rights of ownership as well as arrangements for the pet's ongoing care. So this may include who will have sole care of the pet, contact arrangements, microchipping, who will meet the pet's expenses, so things like food, vet bills, grooming, pet insurance. In the case of working pets, if I can call them that, there may also be provisions in the pet nup about who takes the pet to competitions. I'm thinking here about, say, racehorses or dogs who enter in crufts, who covers the cost of entering those competitions and all the extra costs associated with that. So pet nups can be really comprehensive and tailored to the specific needs of the parties and their treasured pets. And I think it's certainly advisable to give proper thought to the subject of who keeps the family pets and what happens to them post-separation. And, you know, some pets, for example, tortoises, can outlive their owners. So it's clear that this really does need to be thought through in advance. But even cats, you know, living about 15 to 20 years, horses, about 25 to 30 years. So it's definitely worthwhile drawing up a pet nup in anticipation of things potentially going wrong later on down the line. And certainly the Law Society has specifically encouraged and endorsed use of pet nups to preempt issues such as who retains ownership of the pet and so on. So I've included on the next slide a couple of standard form documents for pet nups. One of them is produced by the Blue Cross, and they have a pet nup, which is a more detailed document, and a deed of agreement, which is a more simplistic document. Maguire Family Law have also produced their own pet nup templates. These slides will be made available to the audience after the webinar. So if anyone is interested in taking a look at the template pet nups, and perhaps for those who haven't seen one before, and I definitely suggest clicking on the links and just having a quick glance through. What I would say is, although these templates are in existence, I would strongly encourage clients to obtain proper legal advice and bespoke assistance with drafting a pet nup, just to make sure it's really tailored to what they need, rather than simply relying on these templates, although they are a very useful starting point. Okay, so are pet nups legally binding? The million-dollar question. So as with pre- and post-nuptial agreements, the law doesn't currently recognise pet nups as being legally binding. It is decided on a case-by-case basis, and it's ultimately the decision of the court as to whether a pet nup should be enforced. That said, the court is placing increasing weight on such agreements, particularly in circumstances where it's clear that both parties knew what agreement they were entering into, they obtained legal advice, and they entered into the agreement of their own free will. So although it is true that pet nups aren't technically binding, Parties can at least retain some control over what happens to their beloved pet if they do decide to have a pet nut. And as I say, they can be quite influential to the overall outcome. So it's definitely something worth giving careful thought to. So Katherine has already helpfully taken us through the approach to pets in financial remedies in this jurisdiction. In other words, the application of strict property law principles and pets as chattels. I'm now going to talk very briefly about an alternative approach, which is a welfare-based approach. And in some countries, such as the US, Israel, and Switzerland, they are very much paving the way for a welfare-based approach to pet custody post-separation. And when I say welfare-based approach, what I really mean is an approach sort of akin to Children Act proceedings and Section 8 orders. So we're really looking at an animal welfare-led approach. What's going to be best for them? So I've put on the slide some factors that may be relevant to the judge's determination in applying a welfare-based test. So here we're really thinking about lifestyle considerations. So for example, does one party work full-time? Do they have a dog-friendly office that they can take their pet to? What are the surroundings like? Is the animal used to being in the countryside rather than the city? Have they lived in the same house their whole life and therefore would perhaps prefer to be in familiar surroundings? Judge will also look at things like the attachment to the individual. So who has the strongest bond with the pet? Who does the pet spend the most time with? And will the pet be kept with the children of the family? So some quite wide-ranging considerations that can feed into that best interest assessment. And in some of these, in some cases in other jurisdictions, animal welfare psychologists and behavioural experts have been instructed to give specific evidence on what is in the best interests of the animal. So that's quite interesting to note, and it will be interesting to see if that is adopted over here. So I'm just going to run through a couple of very short examples of how this welfare-based approach plays out in some other countries. So in 2017, Alaska became the first state in the US to empower judges to take into account the well-being of the animal post-separation. So I've just included an excerpt there of the statute, which enshrines animal welfare. So it says, in a judgment, in an action for divorce or action declaring a marriage void, or at any time after judgment, the court may provide if an animal is owned for the ownership or joint ownership of the animal, considering the well-being of the animal. So really quite pioneering that they've codified that in their statute. Got another Alaskan example here, the case of Juelfs and Goff, 2022. So this predates the amendment to the Alaskan divorce statute by quite some way, but we can clearly see here safety considerations playing a role in ensuring animal welfare prevailed over the application of property law principles. So in this case, the Alaskan Supreme Court upheld the award of sole custody of the family dog to the husband. The reason being that the dog was at risk of physical injury at the wife's residence because she now had other dogs living with her, which were deemed a threat to the family dog. So in the interest of the dog's safety and avoiding physical injury being incurred, the judge decided that the family dog should go to the husband and not the wife. So I've got another example here, Plony and Plonit, 2004. So this is an Israeli case where the court adopted a good of the animal test. So this case concerned an unmarried couple who, during the course of their relationship, rescued a street cat and an ailing dog. And when they separated, the woman left the couple's home, taking the cat and the dog with her. And her former partner subsequently petitioned for joint custody of the pets, or alternatively for him and his ex-partner to keep one pet each. So the court here decided to adopt a good of the animal test and heard expert evidence from an animal behavioural psychologist. And that evidence proved decisive in enabling the woman to keep both pets on the basis that that would best meet their welfare needs. So, having had a very brief look at what some other jurisdictions are doing in this area at the moment, is there scope for reform in English and Welsh law? Arguably, the treatment of pets and their status in family law is somewhat behind other areas of law in England and Wales and comparable law in other jurisdictions. And it certainly seems clear that there is scope for reforming English law to move away from the strict application of property law principles and perhaps towards a welfare-based approach to this issue. Having said that, I don't know how much appetite there is for moving towards a welfare-based approach. And whilst there are clear benefits, pros being that animal welfare will be better promoted, and perhaps slightly outdated law can be modernised, there are also some cons. So, for instance, proportionality considerations are at play, and there is the additional cost to think about. So, if you're instructing an animal expert, that will incur considerable expense. It may also increase delay and lead to further litigation down the line. So, for example, if the pet custody arrangements don't work out, it may open the door for parties to return to court to re-argue the issue of what's in the best interests of the pet. And it may be that for clients who want to draw a line in the sand, that would be very unattractive to have to come back to court to relitigate the issue of the pet. Katherine, what do you think about reforming this area of English law? Do you have any views?
It is difficult because I can see the floodgates argument, but I do think we've got to the stage where we shouldn't be relying so heavily on only the out of court dispute resolutions, and there should be a structure in place for if those don't work, or if parties haven't planned ahead and entered into a pet nut, there should be a mechanism or structure in place for determination of these disputes in court, having in mind to what's best for the animal. But yeah, it will be interesting to see developments in the coming years, particularly with as the sentience bill progresses.
Yeah, I think that's really interesting. I would tend to agree. I think pets are in a class of their own, and although the law tells us we're to treat them no differently to a sofa or a painting or a fridge, the reality is they're very much seen as members of the family. They are sentient. They have, feelings and thoughts, and a consciousness. And so I think there is definitely room for adjusting our approach to take into account some welfare considerations. Yeah, I agree. Thank you. And thank you everyone for joining us this evening on what's been the third and final webinar in this webinar series. But keep your eyes peeled for the new series that will be starting in spring of next year. And in the meantime, all the webinars are on the Chambers YouTube channel, so you can watch them, and the slides from today's webinar will also be sent out, as Charmaine's already said, or they'll be emailed out. So thank you again, and very good evening. Thank you very much. Good evening, everyone.